So I want to welcome everyone here to our first Lunch and Learn for a while. We have not had one for a while. So I want to thank everyone for joining us today. And I very much want to thank Rishi Bandhu, who's joining us today. He's an expert in employment law, and he's going to be taking us through some pretty timely topics today. So please make sure that you put your questions in the chat, and that we will leave some room at the end of that. So I'll hand over the meeting to Rishi Bandhu from Bandhu Law Professional Corporation, and I'll mute myself. And Rishi, you've got the floor.
Thanks so much, Melanie. It's a pleasure to be with you all today. Nice to meet you. Hopefully what I have to share today is going to be helpful. I know eavesdropping in that initial conversation between Melanie and Paul, of course, everybody's struggling with hiring these days and finding people, which is sort of the opposite end of the spectrum of what we're talking about today, which is ending relationships. But no doubt those things go hand in hand, right? When we're hiring people, inevitably a percentage of those relationships aren't going to work out, and we need to end that relationship. And it can be one of the most stressful things that a business owner, operator, or manager has to deal with, simply because of the time involved with it, the nuisance of dealing with lawyers, your own lawyer. Hopefully that's a little more pleasant, but opposing counsel certainly can be difficult to deal with, and then not to mention the cost of it. It's as we'll talk about today. It's often the case that employers are really taken aback by the cost of terminating employment, especially very short service employees. It can be pretty surprising in terms of what they're entitled to. So we'll talk about that today, and then some strategies to minimize that. In terms of me, my background, I'm not sure if you've all had an opportunity to see my bio, but I am a labor and employment lawyer. I have my own practice here in Oakville, and I've been doing this since 2003. So I started as a student at a boutique management side labor and employment law called Hicks Morley. I did my articles there, and then I went to another management side boutique in Brampton. I spent 8 years there, and then after that I went out on my own and started my own practice. So in my practice, I predominantly represent employers. So I give them advice, I prepare contracts for them, try to help them avoid liability. I advise them in relation to employment relationships, when things are starting to go sideways, and trying to help them get back on track and avoid liability. And then I also litigate. So I'm an advocate. So when employment law matters go to trial or to a tribunal, I represent both employers and employees in that respect. So most of my career has been spent advising employers. For the past 10 years or so, I've been representing employees, and I've found it's actually sharpened my perspective, knowledge, and approach, because it's always good to see both sides of the coin. And I think that's made me a better advocate and given me a much better appreciation for the laws and how to avoid issues as an employer. So in terms of what we're going to do today, again, we're talking about terminating the relationships, but there's a few things to first understand in terms of context or background before we can fully appreciate why we need to take terminations of employment seriously and proactively avoid that risk. So number one, employment relationships are contracts, right? Whether they're written or not. So in many cases, employment relationships aren't reduced to writing. It's not ideal, but nevertheless, it occurs quite frequently. But just because there isn't a written contract in place does not mean there is no contract. the law will imply that the parties have a verbal contract of employment. And then a number of terms and conditions are going to be implied into that relationship, including legislation. So we have a number of employment-related statutes and laws that establish minimum standards in the employment relationship, and that's going to apply to an employment contract, whether it's in writing or not. So the most significant source of implied rights and obligations come from the common law. So the common law is essentially the principles of law that have been developed by judges and courts over a long period of time, dating back to when the Commonwealth was entered, and maybe even before, when we were part of the of Great Britain. But essentially, all those principles from the courts are implied in the relationship if it isn't in writing. And now we are able to avoid some of those common law obligations through a written contract. And that is the benefit of doing that. If we have that contract, then we can avoid the law coming around and judges coming around and saying, this is what your contract should be about. One significant theme here in any employment relationship, and what differentiates this from any other commercial contract, and there's no doubt that employment contracts are a subspecies of commercial contracts. But unlike a contract you may enter with another business to provide services, your employment relationships are unique because of the power imbalance, and employees are vulnerable to employers. We as employers hold all the power. We are issuing that paycheck, and employees are dependent on employers for that check. So as a result, employees will tend to sign contracts without reviewing them, without getting legal advice, and they tend to jump into employment relationships without doing a lot of searching, right? I think, given the state of the economy that we're in now and the issue of that we're having with hiring, it's a little bit different now, but that fundamental dynamic will never change, which is that employees are vulnerable and employers hold all the power. Now, because of that vulnerability, as I indicated, we have legislation to provide employees with minimum protections. And the main one that we're going to talk about is the Employment Standards Act. So the Employment Standards Act, which is enforced by the Ministry of Labor, stipulates the floor of rights for employees that we can't go below. So the most obvious ones are minimum wage, vacation entitlements, statutory holidays, overtime. But then there are also minimum requirements with respect to termination of employment. And we'll talk about that. So we have to abide by certain minimums when we're letting people go, in terms of providing notice and possibly severance pay if you qualify for it. And that's something that we'll talk about. So in terms of structure for today, first thing that we'll talk about is without cause versus just cause terminations. Essentially the difference there being when you have to provide notice of termination and when you don't. We'll then talk about the specific statutory entitlements. Then we'll go into what a wrongful dismissal is. And then related to that, the concept of constructive dismissal. We'll talk a little bit about independent contractor relationships and how they are seemingly different from employment relationships, but in many ways the same when it comes to your obligations. And then we'll look at this concept of mitigation of damages, which in many wrongful dismissal cases is the employer's only defense and ability to have any degree of leverage. We'll talk about an employee's obligations in terms of resigning, and then we'll briefly talk about some post-termination obligations of employees after that employment relationship ends, and what you can do as a business to protect yourself from an employee who is left. So firstly, without cause versus just cause terminations. So the fundamental common law rule in an employment relationship is that an employer may terminate at any time for any reason, provided that it gives the employee reasonable notice of termination. And that's called a without cause termination. So our laws, at least in Ontario and all other provinces, reflect this idea that, very sensibly in my view, that employment relationships are not going to work out in many cases, or they can change where an employee at some point in time may be a good fit, but then later is not, maybe because the business has changed, the employee has changed in terms of their expectations, maybe they've grown bored or unmotivated. In any event, employers as a business and in the context of a commercial relationship, they need to have that flexibility to be able to terminate at any time for any reason, provided that it gives reasonable notice. There are some exceptions when it comes to human rights, but for the most part, we have that flexibility. Now, that basic rule that we have to provide notice of termination is exempted where there is just cause for terminating the relationship. So just cause is a high standard, and it essentially means that the employer is entitled to walk the employee out the door and provide them with no notice of termination whatsoever. And that is a very high standard to meet. And it's reserved for significant misconduct or willful non-performance of duties. So theft from the employer, for example, is one example. If it's proven, that will establish just cause. But even there are exceptions. I was reading a case the other day. Now this was in the unionized context, but in that case, it involved the hospital and a nurse, and that nurse became addicted to opiates and was forging the signatures of the doctors that she worked for on prescriptions and then getting these narcotics. A very significant act of dishonesty. She was actually criminally charged for that, but in fact was reinstated by an arbitrator, because that misconduct was a product of her addiction. She was disabled. So even in that case, there can be exceptions, but that's where human rights considerations start to come in. The most difficult thing to do in terms of just cause is to release an employee without any notice because they're not performing their duties, or they're performing their duties at a substandard level. And this is really tricky because it's understood that employees have to perform. You're hiring them to perform a job and you're expecting them to perform at a certain level. And if they don't, there's no point to the employment relationship. The difficulty is what the law expects in order to justify just cause for non-performance is multiple warnings. And oftentimes we don't, as businesses or as employers, have the time to engage in that progressive discipline process. Yet that's what the law expects of us. Provide a warning, escalate that warning to a second or a third one, provide training and coaching to that employee, and warn the employee of the consequences of them not meeting the standard. It happens so often that an employee isn't working out. The employer has had numerous conversations with that employee about the non-performance, but none of that gets reduced to writing. None of it is reflected in a performance improvement plan, and the employee is never warned specifically that their job is in jeopardy. Because that's a hard thing to do. Nobody wants to have those conversations. Nobody wants to look across the table and say, listen, if this doesn't work out, I'm going to have to terminate this relationship. That's a really difficult thing to say. And so we tend to avoid it, yet that's what the law expects of us. So all that is to say, when it comes to non-performance, it's very difficult to terminate on a just cause basis without any notice whatsoever, unless we have that long track record. So instead of that, employers often revert to saying, look, it's not working out. We're going to provide you with notice of termination or payment in lieu of that notice of termination, and we're going to part ways on an amicable basis. That's typically how it's done. So how much notice do you have to provide then in the event of a without cause termination? Well, the first thing that we have to take into account are the statutory entitlements, which I mentioned. And this comes from, in Ontario, the Employment Standards Act. So as I mentioned, these statutory entitlements are intended to address the vulnerability of employees. So common law rules can have harsh consequences in the hands of self-interested employers. And what are those common law rules? Well, what the common law says is that when we want to let someone go, we have to provide notice that is reasonable in the circumstances. And what is reasonable will depend on the employee's age, their length of service, the character of their employment, and their ability to find similar alternative employment. And that too is subject to a duty to mitigate. So if the employee can find another job fairly quickly, then the employer doesn't owe the employee anything. So as a result of those common law rules, there's some ambiguity, and the employer has some rights to not provide notice or payment in lieu of notice if another job is found. So a lot of games can be played by employers where they can say, look, you're a short service employee. I'm only going to give you a week, and you're going to find another job fairly quickly. So that's all you're going to get. And if you don't like it, go ahead and sue us, right? In which case the employee is going to have to go find a lawyer, pay a retainer, and then maybe wait up to 2 years in order to get their reasonable notice entitlement. So when employers have that power, they can play these games. So as a result of that, statutory entitlements have arisen to provide minimum standards with respect to termination. And in Ontario, it's either the Employment Standards Act or the Canada Labour Code. Now, the Employment Standards Act is going to apply to the vast majority of employers, unless you're operating in an industry that's federally regulated. And those industries would include things like banking, telecommunications, or interprovincial transportation. Those are the big three there, or broadcasting. And so they're typically larger scale employers, although the most frequent source of employer that gets caught up in the Canada Labour Code is transportation companies. But so we're either talking about the Employment Standards Act or the Canada Labour Code, and there are some important differences that we'll talk about. The important thing here is that employers cannot go below those minimum standards. So what are those minimum standards? So starting with the Employment Standards Act, and now again, the Employment Standards Act is going to apply to the vast majority of employers. So if you're manufacturing, if you're retail, if you're food services, hospitality, financial services, the Employment Standards Act is going to apply to you. So as noted, it's applicable to employers regulated by Ontario law. And the first obligation is notice of termination or termination pay. essentially payment in lieu of notice of termination, which will range from 1 week to 8 weeks. So as soon as an employee crosses 3 months of service, they become entitled to at least 1 week of notice or termination pay. After 1 year of employment, that goes up to 2 weeks. And then after three years, it goes to 3 weeks, and then it steps up a week to a maximum of 8 weeks after 8 years. Right? So that's the minimum obligation that we have to provide. And during that period, we have to provide all forms of compensation that they would have earned, including continuation of benefits. Now, a second obligation is called severance pay. And these things, severance pay is often confused with termination pay, but it's in fact a distinct obligation that does not apply to every employer. Where it applies, the obligation is 1 week per year of service to a maximum of 26 weeks. So once you hit 26 years of service, it's 26 weeks. But there are two key conditions here, which means that severance pay is only applicable to a narrow subset of employers. So number one, the employee has over 5 years of service. And two, the employer's payroll exceeds $2.5 million per year. I actually need to make a correction to that. It's actually worldwide payroll. So if you've got a large organization that has a small operation in Ontario, they will still meet that threshold. So that's the Employment Standards Act. Those are the basic minimum obligations for termination of employment. Now, we talked about the Canada Labor Code, applicable to federally regulated employers. So if you are a transportation company, for example, the Canada Labor Code would apply to you. Now, the Canada Labor Code has less generous notice of termination and severance entitlements for employees. So for notice of termination, it's 2 weeks of notice, and then severance is 2 days per year of service, and that starts to kick in after, I think it's 1 year of employment. So when you're talking about a 5-year employee, the entitlements to terminate an employee, or the requirements to terminate an employee under the Canada Labor Code, are much less generous than the Employment Standards Act. But there's a wrinkle, and that is that if you're governed by the Canada Labor Code, you cannot terminate without just cause. So you have to have just cause to terminate. And as I mentioned, that's significant misconduct or significant non-performance of duties. That's the only circumstance. So banks, for example, if you have employment with a bank and you're not a manager, you would be entitled to just cause protection. And so the bank cannot simply let you go by saying, sorry, it's not working out, you're not a good fit. And in those circumstances, the employee could make an application to the Canadian Industrial Relations Board, complain that they've been unjustly dismissed, and quite possibly could have their employment reinstated with the bank. That doesn't happen very often, but what it does do is it increases significantly the federally regulated employer's obligation to provide compensation when they terminate employment. All right, so those are the minimum standards, right? And so at a minimum, we have to comply. If you're an ESA regulated employee, at a minimum, you have to comply with those minimum requirements. But as I mentioned, you may have to pay quite a bit more because of this concept of reasonable notice and the common law. I'll talk a little bit more about that, but the most important thing or question that employers have is, how can I avoid the cost and uncertainty of terminating employment? And the answer to that is a written contract of employment. Now, what the written contract of employment will allow an employer to do is limit their obligations to the minimum standards under the ESA. And this is a typical clause, right? Except where so-and-so is entitled to terminate your employment without notice pursuant to the Employment Standards Act. We may terminate by providing you with notice, payment in lieu of notice, or a combination of both, and severance pay if applicable, in accordance with the provisions and requirements of the ESA as it may be amended from time to time or as may be replaced by future legislation. And on termination without cause, your entitlements are limited to those prescribed by the ESA, and no further notice, payment in lieu of notice will be provided to you. You'll receive your full entitlement to compensation under the ESA, including continuing to participate in the group benefit plan. So effectively, what this clause is purporting to do is to tell this employee that when we let you go, the only thing that you're going to get is what we are required to provide to you at a bare minimum under the Employment Standards Act, and you're not going to get anything further. Right? So a lot of clauses look like this, but what happens with litigation and with plaintiffs' lawyers is they attack these clauses, and they attack them by saying you're contracting below the Employment Standards Act, or you're being ambiguous about what the employee's entitlements are. And so as an example, this clause could potentially be attacked because in the second paragraph, it talks about on termination without cause, your entitlements are limited to the ESA. Now, some lawyers will suggest that is unlawful, because what it's suggesting is that if there is just cause, then you won't even get the ESA. Right? And the reason that is unlawful is because just cause is not the standard for denying someone their Employment Standards Act minimums. The standard for denying someone their Employment Standards Act minimums is actually a standard that's higher than just cause. And it's called willful misconduct, disobedience, or willful neglect of duty. And so the courts have said that that's a much higher standard. So in drafting these termination provisions, it's very important that you have counsel who's well-versed in employment law review the contract to ensure that it's compliant with the ESA and that it's not going to be subject to attack by another employment lawyer. But if you do that, it's the most effective way of minimizing your obligations. Again, we can't go below the ESA, but what we can do is promise to provide at least the ESA and nothing more than that. So then what is a wrongful dismissal, right? And there's often a lot of confusion about that, because particularly from employees, because a lot of employees believe that employers have to have a good reason to terminate, right? They're often upset when they get let go, and they demand a reason. They feel that it's unfair. But in fact, as I mentioned, the employer has quite a bit of flexibility to terminate that relationship if it's not working out for the business. So what is a wrongful dismissal then? A wrongful dismissal is in fact a very narrow definition, which is a court action against a former employer for failing to provide reasonable notice of termination. It is essentially a breach of contract lawsuit, and the breach, or the alleged breach, is the failure to provide reasonable notice of termination. And so I briefly mentioned how we assess reasonable notice, but they'll typically look at the following factors: age, length of service, character of employment, ability to find similar employment. So the test is highly fact-driven. It's very much discretionary, and the decision is going to be guided by prior court decisions. So it's not uncommon to see lawsuits involving senior executives who may be employed for a very short period of time, say 18 to 24 months, making quite a bit of money, maybe $250,000 a year plus. And in those lawsuits for wrongful dismissal, the employee is claiming up to 12 months of notice. And there are cases that have awarded that. And so the difficulty is there's a range of notice, right? The employer will say, well, there's this case that says 6 months are appropriate. The plaintiff will say that these cases say that 12 months are appropriate. And then this whole issue goes before a judge, and the judge decides what's appropriate in the circumstances. So wrongful dismissals become messy, expensive, and difficult to manage, and oftentimes employers are on the losing end. And when you're on the losing end of a wrongful dismissal action, you're paying your fees, you're paying whatever the judge says you have to pay, and then you're paying a portion of the legal fees of the other side. So again, the way to avoid all of that is a nice, tight employment contract that either, number one, limits the employer's obligations to the Employment Standards Act minimums, or defines an alternative notice period that complies with the ESA and which is enforceable. In either circumstance, if that's properly done and the contract is validly entered, then there is no wrongful dismissal, because the employee's entitlement to notice and severance is specified in the contract. There is no breach of contract if that's complied with, and then there's no lawsuit. All right, so that's a wrongful dismissal. Now, to further complicate the matter, there is this idea of constructive dismissal. And so a constructive dismissal is a lawsuit that the employee undertakes in circumstances where the employer has actually not taken steps to terminate the relationship. And in fact, the employer has probably said that they have no intention of terminating the relationship. They want it to continue. So where a constructive dismissal arises is where the employer acts in a manner that's fundamentally inconsistent with the party's agreement and would permit the employee to resign on the basis that the employee could turn around and say, hey, that's not our agreement. That's not what we agreed to. You're changing it. So I have no further obligation under this relationship, and you have effectively terminated me. So I'm going to resign and sue for constructive dismissal or wrongful dismissal. And so the courts recognize two branches of constructive dismissal. One branch is where the employer unilaterally changes a term or condition of employment that is considered substantial in the eyes of a reasonable third person. Right. So the classic example of that is the employer drops an employee's remuneration or compensation by 20%. A pretty steep drop, and in that case, the employer didn't have a right to do that, so the employee would have the ability to sue for constructive dismissal. Second scenario is where the employer conducts itself in a manner suggesting that it no longer intends to be bound by the contract of employment. So essentially, they haven't really changed any term and condition of employment, but they're acting in such a manner or conducting itself in such a manner that a reasonable third party looking at the situation would say, this employer actually doesn't want this employee around, or they don't want to abide by the terms and conditions of their employment relationship. And so common forms of constructive dismissal that we see are, as I mentioned, compensation changes, layoffs without express authority, or bullying and harassment. So a layoff without express contractual authority would fall into that first branch. And this is one of those situations that we're seeing in the courts right now because of COVID. We all know what happened in March of 2020 all these lockdowns happened, employers had no option but to lay off significant portions of their workforce. But they were sued for constructive dismissal, a lot of them, because they didn't have express contractual authority to lay off temporarily. And what our common law says is that if you as an employer want to lay off or want to reserve that ability to lay off, you need to write that directly into your contract of employment. The employer does not have an implied right to suspend the relationship or to lay off for a period of time. And so that's currently being litigated, and it's been complicated by changes to the Employment Standards Act to address COVID, including this emergency infectious disease emergency leave. Created a great deal of confusion there because those changes said that an employer who lays off does not constructively dismiss for the purposes of the Employment Standards Act. That was clear, but what about the common law? So if someone laid off, they may not have a cause of action to the Ministry of Labor, but can they still sue for constructive dismissal under the common law? And that's a decision that's we're still waiting for to clarify from the courts. Another example of a constructive dismissal could be bullying and harassment, and this would be an example of the second branch of constructive dismissal. So where the employer itself bullies, harasses an employee to the point where the employee can no longer stay in that relationship, that employee may have a cause of action for constructive dismissal. Alternatively, if the employee is a victim of bullying and harassment by another employee, and the employer does nothing to address that or doesn't address it in a satisfactory way, that could also lead to a constructive dismissal. Now, the saving grace in these constructive dismissals is they're very difficult to prove. So, give you an example of one case that I'm dealing with right now. An employee and an employer agreed that the employee would work from home, and the employment relationship previously was that it was the duties were performed from the employer's workplace. They didn't paper the agreement properly. It was all by text message, and the employer said in that text message that, you know, this is the arrangement we'll put in place. You'll work from home 2 days a week, and we'll see how that goes. And so the arrangement continues for a period of time, say 18 months. And then after that period of time, the employer goes back to the employee and says, I want you back to the office now. And the employee says, no, I'm not doing that. I don't even work from home. I'm off 2 days a week. I work 3 days a week from the office. And so we're saying, no, that's not the case. We always said you would be working from home. We said it was subject to change. And we're exercising our right to bring you back to the office. And the employee says, no, you've constructively dismissed me. And so now they're suing for constructive dismissal. You know, it's going to be a difficult one for the employee because there are these text messages in place that say that the arrangement was subject to change and that she was working from home. So you know, the employee's got a lot of risk in this situation because the employer didn't take steps to actually terminate the relationship. And their argument is that they're simply reverting back to where the relationship used to be. And they always intended for that to happen. So that's a very challenging case for the employee to make. But nevertheless, it's also very challenging for the employer as well. And it can't be said that they have zero risk in this situation. They have a considerable amount of risk, in part because the invulnerability of employees and because courts tend to protect that. So it's unclear how that's going to go. But it is an example of an issue that's happened with quite a bit of frequency right now with other employers, and as a result of COVID, so many employees have, particularly in the legal industry, have been working from home, and now employers want them back in the office, and they're saying no. I moved away. I moved to Kincardine or Halliburton or wherever. I have internet access. Everything can be done by Zoom. There's no need for me to come to the office, and that's creating quite a bit of issue. But I think that's the problem. There is employees are looking at the situation saying, well, what's your problem? I'm doing my job. I'm doing my job as well as I've ever done. You have no concerns with my performance. I can do my job from home. Why do you need me back in the office? Right? And this is where the constructive dismissal analysis comes in, because the employer's argument in that case is, it's not what you think. It's not what you perceive. It's not what you want. It's what we agreed to. It's what this contract is about. And it's what a reasonable third party looking at this situation is going to think, right? And that's a fundamental challenge that employees have with constructive dismissal, right? Number one, the employer hasn't taken any step to terminate the relationship. And number two, the employee's feelings about the issue are largely irrelevant. It's about what a reasonable third party would think in those circumstances, right? And sometimes that's clear, right? If an employee is being bullied incessantly, any reasonable party looking at that situation is going to say, yeah, nobody has to stay in that relationship and tolerate it. But in other circumstances, it's a lot less clear. I went on a bit of a tangent there. I'm happy to stop for any questions if there are any at this point, and then we can continue on. I know I've been talking incessantly here.
Leslie, I know you had a couple of questions. Did you want to ask those?
Sure. Yeah, I was just trying
to
to.
Chat as well, Leslie.
Pardon me?
I see it in the chat.
Oh, okay. Yeah.
So your first question, in the termination clause, would you recommend adding additional notice or pay in lieu per year of completed service to replace any notice otherwise required at common law? Leslie, I think it depends on every position. Mm-hmm. There's some positions that you're just not going to get away with saying you're going to get the bare minimum, right? For example, executives, right? If you're hiring on a senior vice president and saying, you get nothing within 3 months, or you get 2 weeks after 1 year, they're going to say not a chance, right? They're going to want something more like a month per year. So in those circumstances, yeah, we have to create a contract that gives them something more. Mm-hmm. But it's very tricky, because what happens in a lot of cases is the employer will attempt to give the employee something more than minimums, but then inadvertently contract out of the Employment Standards Act. So there's a case a few years ago that went to the Court of Appeal, where the employer in the contract said, we will give you 2 weeks per year of service, right, as notice or payment in lieu thereof, and that's all you're entitled to, right? Well, what about benefits? You've now excluded benefits from that consideration, and you've said effectively that 2 weeks per year is all you're going to get. Well, you're actually offside of the ESA then, and now that clause gets struck out. And the employer is really upset and really frustrated, because what they've actually tried to do is give the employee something more than the minimums. But the court has come along and said, that's illegal. And now you're back to giving 1, 2, maybe 3 months per year of service, right?
Right.
So you got to be very careful in how we draft these termination clauses to provide that additional notice. Mm-hmm. What I've started doing in my practice is I have 2 components. I've said, when we terminate you, you're going to get the minimums and that's it. That's clause A. Clause B is, here is your additional severance entitlement, right? So there's no question then in that circumstance, provided that I draft that correctly, that they're going to get the minimums, because that's always the issue. Are you contracting below the Employment Standards Act? And if you do that, either inadvertently, accidentally, or ambiguously, the clause gets struck.
Mhm. Okay, great. Yeah, I had drafted it for one client who had no employment contracts and had long-term employees. One was there 20 years. So,
Yeah.
and in the clause, I had written that they were, so they would get the minimum requirements of prevailing employment standards legislation, plus an additional 2 weeks notice or paid lieu, up to a maximum of 24 additional weeks.
Yeah.
To try and limit exposure for the client.
Yeah. Conceptually, that's the way to do it.
Okay.
If you want me to take a look at it, I'd be happy to and see if. I mean, employment lawyers, plaintiff employment lawyers are notorious for trying to poke holes in this stuff, right?
Right.
The one thing that's causing, and these issues have evolved over the years. At first, the issue was your contract doesn't talk about benefits, and the ESA requires benefits. So because of that, you're contracting below the ESA.
Right.
And then employers fixed all of their contracts to say, don't worry, you're getting your benefits, right? And so they fixed that. But then we had this just cause language in there, and these contracts were saying, if we let you go for just cause, you get nothing at all. And if we don't have just cause, then we give you the ESA. And the problem with that, as I mentioned, is just cause is not the standard for denying ESA entitlements. The standard for denying ESA entitlements is willful misconduct, disobedience, or willful neglect of duty.
Right.
And that's a higher standard than just cause. It's really silly, right? The way we split hairs on this stuff, just to say, willful misconduct is somehow more serious than just cause. But this is what lawyers and judges do, right?
Right.
But in any event, if your contracts have this language of just cause in it, you got to be very careful with that, because that could be an automatic invalidation of the contract.
Right. No, it said without cause. There was no just cause.
But that could be a problem though, right? Because cause and just cause are synonymous, right? And if it says in the event of without cause, you'll get this, the inference is that if we have cause, you don't get anything.
True.
Right? So we've got to be careful there. And so what I've done in my contracts is I've actually defined cause, right? I'm saying, look, if we let you go for cause, what that means is that you've engaged in willful misconduct, neglect of duty, or disobedience contrary to the ESA.
Okay.
So I'm effectively adopting that higher standard in all the contracts so that it can't be attacked.
Right. Perfect. Thank you.
You're welcome. And I think I might have answered your question on constructive dismissal, unless.
Yeah. So I'm working with another client who I'm updating job descriptions that haven't been updated since the 1990s. So I just wondered, and things have changed radically, obviously.
Yeah.
And I just wondered if there's a line that I would cross by making too many changes, or, I know we can update them for sure, but I just wondered what the bar would be in terms of.
It's I think where the change is substantial, significant, fundamental, right? Those are the sort of the catchwords, right? If we're saying, your duties are changing in a slight way, maybe you take on one additional task, or once a week you do something else, that's probably okay. But where you're changing the position fundamentally, so taking them from a high status position like management to a lower status position, that'll be a constructive dismissal.
Right. Or
where you're changing hours significantly, right? That'll be a constructive dismissal as well. But minor tweaks, no. I mean, in the end, we've got to look at this from perspective of a third party, not from the perspective of the employer or the employee, but some third party looking at this saying, is that a reasonable change?
Mhm.
Is that something that someone should accept?
Okay, great. Thank you.
You're welcome. Karen, as it relates to constructive dismissal, an employer hired someone in a professional role. The employee may have misrepresented their experience and is struggling, affecting the rest of the firm. The employer wants to meet with the employee and present a plan. There will be to gain the experience, there'll be no reduction in pay during this period, but could the employee consider this a constructive dismissal because they will be working at the same level as senior techs in the firm? Hard to say. I mean, I guess if the misrepresentation is very clear and very obvious, I think there's an issue of misconduct there, which may give the employer the right to terminate the relationship with cause, potentially. So in that circumstance, it may be a reasonable change, but this is the type of thing where advice may be required and a longer discussion about the facts of this, and some discussion with the employee as well, right? At the end of the day, you don't have a constructive dismissal if there's consent to the change, right? So if the employee buys into it, there's no issue. So in these circumstances, if there's been a misrepresentation and despite that, the employer wants to continue the relationship, I'd be saying, let's have a conversation about this, right?
And he does want to keep this person and help them develop. So
right.
Yeah.
So then I think the way to avoid the constructive dismissal is to have that conversation with the employee, right? Get their buy-in, get their consent, and if that's the case, then there is no constructive dismissal. If the employer is going to force the change on the employee, then looking at it narrowly, there's an argument there for constructive dismissal, but I suppose the defense would be a misrepresentation. Kind of a unique set of facts. So it could go either way on that, but I think the answer to that is dialogue and consent.
Okay.
All right, Wendy, what about terminating the relationship during the probation period, and if the probation period is clearly defined in the offer of employment and the employee signs off before starting the position? Yeah, I mean, that's fair. We can have a probation period. There is no implied probationary period. So if you want a probationary period, it has to be written into the contract. That contract has to be validly entered into, but provided that it's done properly, then yes. Question 2, should a layoff clause be included in all job offers to protect the employer? Yes, absolutely. As I mentioned, there is no implied right to lay off. So if you don't have it in the offer of employment, and then you lay off, it could very well be a constructive dismissal. Melanie, in terms of consent, would an email exchange suffice, or do you need a more formal sign-off? Can probationary periods be extended? In terms of consent, would an email exchange suffice? Yeah, I think so, provided that it's crystal clear. A formal sign-off is crystal clear. But I mean, I think we've come to a point where we've acknowledged that emails are a valid, lawful form of communication. So a handwritten signature is not necessarily important anymore. If the employer's practice is to say, here's your employment agreement, please respond with an affirmation that it's agreeable, by reply email, then that should suffice. But of course, the classic way of doing it is to have that signature in writing, maybe use DocuSign, and they're signing in a specific place on the contract. And so that signature, the acceptance, is all part of the contract and not contained in a different agreement. Can probationary periods be extended? Sure, they can, provided that you're complying with the Employment Standards Act, and you have the right to do that. So, if you have a probationary period in your contract that allows you to let them go within 3 months without any notice whatsoever, you can do that, and then you can extend that to 6 months. But you still have to comply with the Employment Standards Act, because the ESA says that after 3 months of employment, they're entitled to at least 1 week of notice. So you have to comply with that. You wouldn't be able to let them go after 3 months without any notice whatsoever.
Rishi, I had a question too about progressive discipline. So I know we get this question from a lot of our members in regards to how formal, if you're putting someone on a performance improvement plan, and a lot of small businesses struggle with this because they don't have internal HR. So when you're putting someone on a progressive plan, for example, do you need them again to consent to that process in writing or via email?
No,
and that they acknowledge that there's an issue?
No, not necessarily. I mean, as employers, we have the right to manage the business and manage expectations and to correct performance, right? We have that right. The problem is that we don't do it, right? It's because it's time consuming, right? And we expect people to know their job and to do it, and we don't want to invest that time, right? But it doesn't have to be overly formal. The employee doesn't have to consent to the process. The employer simply has to communicate their expectations and the deficiencies in meeting those expectations and the consequence for continuing to fail to meet those expectations. That's what we require at a bare minimum. And so if the employer does that and the employee doesn't accept it, they do so at their peril, right? Because that's just going to hasten the process or facilitate the process towards termination.
What's the number one mistake besides the employment contract that you see employers make when dealing with their employees?
The number one mistake. There's so many. I mean, not entering a contract is one. Second is not entering a contract properly, right? So oftentimes employers will ask me to provide a contract. I'll do that, and they'll bring the employee in on the first day of employment. After they've already agreed on the terms and conditions, on the pay and the start date and that sort of thing, they'll say, "Oh, here's just some paperwork I need you to sign," right? And then they sign it. No opportunity for legal advice, right? And that's a fundamental mistake too. Or alternatively, the employee starts and then a week later, the employer says, "Oh, by the way, I need you to sign some paperwork," right? And the employee says, "Sure, no problem," and they sign off on it. But the employment started a week before. So in those circumstances, that contract is going to be invalidated because there's no consideration for it, right? The agreement is already formed at the outset when they started the relationship, right? And that contract now represents a change or an alteration of what's been already agreed to. And there's no additional monetary consideration to support it. So the court will invalidate that contract.
So would that include policy manuals like Leslie's referred to, and then so if you've got employee policies in terms of confidentiality, et cetera, you should send that all as part of the initial job offer?
Yeah, I mean, policies are a little bit different. Ideally, they don't rise to the level of contractual terms. But ideally, what you want to do in your contract is you want to have a term that says you will agree to abide by all the policies, right? Now, if you have that and then you have policies after the fact, that should be fine, provided that those policies aren't altering fundamental terms and conditions of employment. So, for example, if your contract doesn't have a termination clause, and you say our policies form part of this contract, and then in that policy it says we can let you go by providing you with the minimums, that's an alteration, right? That's an alteration of the contract, and it's not going to be enforceable. All right. Should we motor on?
I think so. Yeah, those were great answers.
Yeah, and there's another common mistake that we'll touch on in a minute. So briefly, a word about independent contractor relationships. So a lot of organizations have them. They're not considered employees under the law, and so they're like the guy, the plumber that we call to our house to fix something, or the contractor that we've called to finish our basement, right? These people are not our employees. They're bringing their own tools. They have their own employees. They work on their own schedule, subject to a rough guideline. They're not dependent on us. They have other work. So that's not what the Employment Standards Act or the common law is intended to protect. However, these relationships can be challenged, and it's not the label that's placed on these relationships, but it's the actual substance of the relationship and how they are functioning in practice. And so the courts will apply a functional test to the determination of whether or not someone is a contractor or an employee, and it's fact-driven. So it relies on how exclusive is the relationship. Is that person only working for you? And how dependent are they on that income? If that's the only source of their income, and there's a high degree of control over that relationship by the employer, then even if the parties have considered that relationship to be an independent contractor relationship, it could in fact be characterized as an employment relationship. And if that's the case, then the Employment Standards Act applies, and potentially reasonable notice applies. Now, to complicate it further, there's a category of relationships called dependent contractors. Right? And so these are people we may be paying as contractors, but they have a degree of dependence on the employer. And so as a result of that, the courts have said that those types of individuals are actually entitled to reasonable notice and statutory protections. So we have to be very careful with independent contractor relationships, and we have to understand the risk with it. And so we may decide to enter into an independent contractor relationship. But if we do that, we need to understand that relationship can be challenged by that employee later on. So let's talk about extraordinary damages. And this is where, there's a great deal of risk for employers, and the degree to which we are seeing extraordinary damages awarded by courts to employees is increasing in recent years. So these would be damages for mental distress, aggravated damages, or punitive damages, which are intended to punish the employee for their poor behavior. And so in a wrongful dismissal action, the core of the action involves a claim for damages in lieu of reasonable notice of termination. So it is effectively the money that would have been earned by the employee had they been given notice of termination. And extraordinary damages are well beyond that. And so where extraordinary damages arise is where the employer behaves poorly. And so the law implies a duty of good faith and honesty in the relationship. And so the employer has to be candid, reasonable, forthright, not engage in acts of dishonesty, and be kind and empathetic at the time of dismissal. And if they are overly harsh or make accusation of just cause, that's a typical example, right? Where an employer wants to avoid severance obligations, and they will, construct at a very thin facts an argument of just cause, which is very damaging to an employee's self-esteem. That can attract damages for bad faith, right? So traditionally, the courts have said that there is no obligation to provide good faith reasons, right? We as an employer don't have to provide a reasonable business justification for a dismissal, right? In other words, an employee can't come around and say, you have to justify why it makes appropriate business sense to terminate my relationship. Courts don't want to go down there. They don't want to question employers' motives. They want to give employers the flexibility to be able to terminate relationships so that they can protect their business and remain nimble and be able to respond to economic pressures. So we don't have to have good faith reasons, but that concept is evolving, right? And as it stands right now, employers simply have to act honestly and in good faith in the manner of dismissal. Thirdly, as an exception to this idea that we can terminate for any reason at any time, we cannot terminate for reasons that are contrary to human rights legislation. So if we are letting an employee go because of a disability, because they can't work, or because of their gender, their sexual orientation, or their gender identity, we've all seen the news about Oakville Trafalgar High School, right? With this teacher who's transgendered and is coming to class with these oversized prosthetic breasts, right? And the school board and the school have very clearly come down on the side of this teacher, saying we're protecting this employee's right to gender identity and expression, right? So, and that's exactly what it is. It's a human rights issue. Without that, they would be able to terminate by saying, we don't need this in our school, right? Leaving aside the unionized issue, but they'd be able to terminate and say, we don't want this distraction. What you do in your personal life is your business. We don't want it in our school. I'm sorry, can't dress like that. If you refuse to comply, you're going to be let go. We can't do that because of human rights considerations. And again, as I mentioned, conduct that is deliberately misleading, bullying, intimidating, or malicious can lead to punitive damages. So punitive damages where the court takes a dim view of the employer's conduct and says, I want to deter this conduct. I want to send a message to other employers that this type of conduct is unacceptable, and they will assign a monetary value. And quite frequently, what we're seeing these days is awards of at a minimum $25,000, tax-free, that goes directly to the employee. And depending on the size of the employer, that could increase. The largest award, I believe, is $500,000, which was awarded against Walmart a couple of years ago. And those we don't see very, very often, but the frequency with which courts are handing out these punitive damages awards are definitely increasing. So we need to take a great deal of care in how we terminate and the manner of termination. So I spoke earlier about mitigation, and oftentimes this is the only defense that an employer has to a wrongful dismissal lawsuit. So employees have a duty to search for and accept reasonable alternative employment after dismissal, which is comparable to the lost job, regardless of the reason for dismissal, right? So in any contract, the party that's aggrieved or is claiming a loss has an obligation to try and minimize that damage. And if they do minimize that damage or avoid it altogether, then they don't have a lawsuit. Alternatively, if they don't take steps to avoid the loss, then the judge can penalize them. So it often happens where an employee is let go and they don't do anything for a number of months. They simply sit on the couch and do nothing at all. And in those cases, the employer will come, the judge will come back and say, "I'm sorry, you failed to mitigate your loss." And oftentimes that's the only defense that an employer has to a wrongful dismissal lawsuit. So they've let someone go, they've complied with the statutory minimums, they haven't given anything more, although they're obliged to provide reasonable notice. And so what they will argue is that the employee has failed to mitigate their damages. Now, with respect to resignations, the legislation doesn't mandate a minimum requirement for resignations, but these things are often spelled out in the contract. So generally speaking, the more senior the position, the longer the expected resignation period. And now there is this cause of action for wrongful resignation lawsuits where an employee doesn't provide adequate notice of resignation. But in my time practicing in almost 20 years, I've never seen one of those lawsuits. And we're unlikely to see it. And the problem is, number one, employees often provide some degree of notice. And secondly, there's typically no damages associated with the failure to provide adequate notice of resignation, right? So, it's disruptive, it's annoying, it's stressful for employers when employees simply walk out the door. But oftentimes that's all it is, and we're not able to assign a financial loss to that breach of contract. So it's just not worth suing for. As well, and oftentimes when an employee just walks out the door without any notice, a lot of times the employer's got some blood on their hands there too, right? So they've done something to cause that resignation. So you don't want to poke the bear when it comes to that. So a lot of times it's just something that you should have in your contract, but in the unfortunate case, if they don't provide adequate notice of resignation, you just have to sort of let it go. The hope in these situations is that an employee will realize that their reputation matters, and that if they hope to continue to work in that industry, they need to be reasonable and they need to be cognizant of not burning bridges. All right, and then the last topic is post-termination obligation. So how can an employer protect itself from an employee that leaves? So under the law, employees may work for a competitor. They may solicit clients unless the contract prohibits them from doing that. And they may solicit employees unless prohibited by contract. All these things by default, the employee is entitled to do. What employees may not do is take and rely upon employers' confidential and proprietary information. That's an employer's property. That restriction is permanent and indefinite. So they can never take that confidential information and rely upon it. They may not solicit clients if they're reasonably prohibited from doing so by contract. Right? So in a contract, you can tell your employee that when this relationship ends, you will not solicit any clients or customers of the employer for a period of time. And that period of time has to be reasonable. And typically 1 year is reflected as a reasonable period. 2 years, likely fine. Anything beyond that, and a court is likely to say that that's unreasonable, and they may strike out the clause. And thirdly, they may not solicit employees if they're reasonably prohibited by contract. Again, you cannot have a contract that says for 5 or 10 years you will not solicit employees. That is likely to be regarded as reasonable and contrary to public policy by the courts. So that, in a nutshell, is post-termination obligations. And that's all we have for today, subject to anything you may want to talk about.
I'm unmuted. Oh, there I'm going. I'm muted there. I had a question in regards to how enforceable non-compete clauses are. So not directly with soliciting clients, but working for a similarly like a competitor.
So the traditional common law rule is that a non-compete clause is unenforceable if a non-solicitation clause would suffice to protect the employer's interests. Okay, so generally speaking, courts have said we do not like non-compete clauses, except in very unusual circumstances, right? Like where the employee is very senior, where they're effectively the identity of the business, and them competing could really destroy that business. In that circumstance, it may be enforceable by a judge. Significantly, late last year, you've probably all heard about Bill 27. The Employment Standards Act was amended to say non-compete clauses are prohibited in all employment contracts unless you're a C-suite officer, CFO, CEO, something like chief legal officer. Those are the only types of circumstances where it may be permissible. For everybody else, they are simply prohibited, right? So the answer is that a non-compete clause is going to be enforced in very narrow circumstances, right? So even if we're talking about a C-suite officer, even in the Employment Standards Act may allow for it, a judge may not permit it. Because of that traditional common law rule that says non-competes are unenforceable if a non-solicitation clause will do.
Okay. And Anna was asking if someone does not work their full resignation time, can benefits be cut off?
So this is a situation where someone gives 2 weeks notice, they leave after a week. Yes. Yeah, because they've walked away from the job. Yeah, the employer hasn't terminated employment in those circumstances. They've essentially abandoned the job, and there's no legal requirement to continue to provide benefits if an employee walks out of the job.
Wouldn't
Rishi,
benefits normally end the day of their resignation, like the day they leave?
I'm sorry, can you repeat that?
So if somebody resigns, say next, in 2 weeks, the day they work those 2 weeks, I mean, they're, okay, never mind. I understand now. Never mind.
Okay.
What about if you give proper notice in lieu of, so let's say you say, in 4 weeks time, your employment is over with us, but you expect the work to continue during those 4 weeks, and the person doesn't show up or doesn't really work. What happens in that case?
Well, the employment relationship is continuing, so the employer continues to have all of their rights to manage the performance of that employee, right? So,
Okay.
so potentially, you know, they could terminate for cause within that notice period.
Gotcha. This is so fascinating. Does anyone else have any other questions for Rishi? I can't see everyone because I've got a different view. This was honestly probably the best hour that I've spent all week. So I want to thank you so much for your time, Rishi. Like your knowledge and your ability to translate some complex issues for us has been really appreciated. And one of the struggles I know
it's all I know how to do.
It's all. No, that's not true. I saw in your bio that you're a softball player and that you've got a lot of other skill sets behind the scenes.
Which I do very poorly.
Oh, well, you know, I know that everyone, I know you're an active member of all the Halton Region chambers, and so we really do appreciate your expertise and that is the challenge that some of our smaller businesses face, is that they just don't have the ability to access this kind of information. I do want to remind everybody that Bandhu Law has offered in their member-to-member discount a 30-minute consultation to all chamber members. So make sure you take advantage of that. It's a really generous offer, and I'm sure you'll be getting some business from our chamber members here today.
Terrific. I appreciate that a lot.
That's super. And the chat is very complimentary. So I think we'll sign off at this point, everyone, unless anyone has any other questions. But we want to say thank you again, and we do appreciate the time and consideration today.
I really appreciate you having me.
Thanks, Rishi.
Wonderful.
Best wishes, everybody.
Thank you.
Bye-bye.